Is welcome to the first of our Start Smart series. I'm Kit Needham with Project Olympus at Carnegie Mellon University, helping students, faculty, and staff explore the commercial potential of their ideas. This series is produced in cooperation with our partners, and I'm going to introduce Rhonda from Pitt.
Hi, thank you, Kit. I'm Rhonda, the director of the Big Idea Center at the University of Pittsburgh. We are Pitt's hub for student innovation and entrepreneurship. So many of our students who we work with partner also with Carnegie Mellon students. So we intersect with a lot of you guys as well. So students, regardless of what institution you're working in, we look forward to having you visit the Big Idea Center.
Yes. And Stephanie?
Hi, I'm Stephanie Dangel. I'm a professor of practice at Pitt Law School. Many years ago, I practiced with David at K&L Gates, and then I spent 10 years working in the local arts and entertainment sector. So I've been now with Pitt about 10 years, teaching courses at the intersection of law and innovation.
I'm just curious, how many, if you could go into the reactions or whatever, and raise your hand if you're a law student.
I see a few.
Okay, so we've got a few of your, hopefully your students or soon to be students in there too. Thank you very much. And lastly, what I want to do is introduce our partner in crime here, David Lehman from K&L Gates, who runs their startup practice, and he's going to be leading the session with color commentary from me, Rhonda, and Stephanie. So, okay, David, you can now introduce yourself and begin.
Oh, well, thank you. And thanks everybody for attending. It's nice to see everybody. At least I see your names. And welcome to the first Start Smart of the season. What today is we're going to talk about just an overview of issues, legal issues, primarily related to startups. And we'll do it sort of in two parts. One is I'll walk through an outline, and then we will do it sort of at a pretty high level, because a lot of the things we're going to talk about we'll go deeper into in some of the other sessions that we do during the course of the year. But the purpose here is to make sure that we at least can identify and know the issues associated with it. And some of them we're going to talk about that you could put off. Some of you deal with it initially, but it's good to have what I call a legal roadmap to understand the legal issues associated with your startup. So at least you can identify them and address them at the appropriate time. I have an outline that we prepared, a checklist essentially that will be available for you folks, so you can have that going forward. But most importantly, it would be great if you ask questions along the way. You can do it before, you can do it during, you can do it after, but you should certainly not wait until I finish talking. So you should interrupt me, put up your hand, tell people, or just interrupt me. I don't care any way you want to do it, but that would be incredibly helpful, because I'm sure I'd rather talk about what you want to talk about rather than what I want to talk about. So, so let me pause there. And maybe I should try to share my screen, for which I usually have various one second. This is host disabled participant screening sharing, so I can't.
Oh, well, no, Rhonda's going to enable you.
Okay.
She's in control. Okay, you're good to go.
Now I'm good to go. All right, cool. All right, so can you folks see my screen?
We can.
Cool. Okay. So at a high level, what we'll talk about is a founders agreement, which is short of incorporation or formation. We'll talk about entity formation. That's item 2 there. We'll talk about founder arrangements, the arrangements between the principals who are putting together their entity. We'll talk about hiring employees and consultants and employees generally going forward, and what you need to think about and what not to think about, either both initially and going forward. We'll talk about intellectual property matters briefly, about NDAs and patent searches and making sure you don't infringe somebody else's patent or IP, and what you do to protect your IP. And most importantly, to think about sort of an approach to it. I want to spend a moment and just make sure we've thought about or thinking about regulatory and matters associated with your business, because it's not just what you decide to do, but it's also lots of governments have things that have things to say about what you're doing. So I want to make sure we've even thought about that. And each business has its own regulatory scheme to comply with, so make sure we've thought about that a little bit. And part of this is thinking about down the road. I mean, for example, I have FDA there as an example, but there are others. And you want to make sure that that you've at least identified those issues going in, so you can so you're not surprised later, because I'll get to that later. And then contract, your business will have lots of contracts with customers and terms and conditions and those kinds of things. And so I want to talk a little bit about make sure we're identifying those and you have a system in place to address those later. Insurance matters, make sure you have adequate insurance in place. I do want to spend one moment on accounting. That's not really technically a legal issue, but I want to make sure you're at least thinking about accounting practices, tax and accounting. Aside from that, we have nothing to talk about. So, those are the categories. And if there's anything you again want to stop on, please stop me. Let me start with the founders agreement, which is the very first thing. And I have optional there because call this a pre-entity formation agreement. This is for founders who have not quite ready to form an entity yet, but you're working on a common endeavor, thinking about doing a business, and you want to make sure that you're all in. And so you think about, who owns the IP and who's going to be participating and who's not going to be participating, what role you're going to play, and basically have a commitment among you that among the founders that as you put some effort into this, it's usually not a whole lot of money, but effort, that you have a commitment by folks that you're going to sign the IP, that you're going to do this together. And what happens if somebody walks away from it and decides not to do it? It's not the most complicated piece of paper, and it can be very complicated. And it can be as complicated as you want. My preference is to go straight to entity formation, because you end up, in a founders agreement, you end up sort of doing a lot of what ifs, which you can deal in the entity formation, so you end up duplicating it. But there are times in life where you just don't want to get to the entity quite yet, and so you want to put this thing together. So that's what that is.
I'm going to add in there too, particularly for those of you who are here on an F1 or a J1 visa, that there are immigration or legal reasons why, although you can form a company, you can own a company, but you don't have legitimate a visa status that allows you to work on your company. So sometimes that's a good reason to delay, and maybe where it might serve you well to actually have some of the founders agreement in place.
Mm-hmm. Agreed. So a lot of the things that we're going to talk about in the entity formation, you can think about, you can use this same checklist essentially in the founders agreement, see whether you want to do it then or not. Then we get to when do you form an entity? And an entity is a good time is when you are going to raise capital, when you're going to sell something, when you're going to license the technology, when you're going to do something. It's a good time to form the entity. And you see it in 1A there, I talk about for-profit, not-for-profit, and I probably skipped one. But I do think it's important initially to think about, is this a for-profit or non-profit enterprise? Nonprofits don't, you can't, it's tautological. You can't make money off of it. It's a very special kind of entity. And so, for example, if you're going to have investors or you really want to make money from it, nonprofit is not the place for you. And there's all kinds of regulatory things if you want it to be tax exempt. If you want, and then there's for-profit, which things enterprises where you actually do want to make money, or you want to at least have the opportunity to make money. And so those are for-profit entities. And then you can have a hybrid, which are the for-profits, benefit corporations, which are for-profits but have a donative or a utility kind of approach. And there's some regulatory requirements associated with that. But fundamentally, you want to think about you for-profit or non-profit in the first instance. Most of our clients are for-profit, but if, for example, you're going to want to get foundation money or donations or those kinds of things, then you want to think about nonprofit status. And yes, it's possible to do both, but it gets really complicated, and most startup budgets can't handle it. Start there. So that, and if you're going to be a for-profit, then you got to think about whether you're going to be an LLC, a corporation, an S corporation, all the kinds of nonprofits, for-profit enterprises that there are. Most people end up being C corporations or limited liability companies for a variety of reasons, which are beyond the scope of this. But just know in the first instance, that isn't an issue. Do you want to be a C corp or do you want to be an LLC, a limited liability company? And so you want to think about that. You also got to think about what state you're going to be formed in. Many people migrate toward Delaware. Why? Because it's a nice state. People like to go there. No, not really. Because it's got, it's one of those things, it's because many people do it. So Delaware is a place where many corporations are formed. It has a very well-formed body of law regarding corporations. Investors like it because they're familiar with it. So many folks go to Delaware, but obviously, if you're you can also do, for example, if you're in Pennsylvania, you can be a Pennsylvania corporation. So you need to pick a state of formation. The name thing,
Have to live in that state.
Pardon me? Was that?
State.
I'm sorry. What was the question?
Or like starting a company in Delaware,
Mm-hmm.
Would you yourself as a founder have to live there, or could you just say, I have a PO box over there?
Great question. You do not need to be in that state. You there are services that you can register with those services, like Corporation Service Corporation is the most classic CSC, and so you for a relatively modest fee, they're your registered office in Delaware. And then you will need to, as you'll see further up and down the road, if you're going to be a Delaware corporation, but you're going to operate somewhere else, you need to register to do business in that other state. So for example, if you're going to have an office here in Pennsylvania, then you'll be formed in Delaware, and then you're registered to do business in Pennsylvania.
Do you file taxes in both?
You'll pay franchise tax in Delaware, but income tax, et cetera, in Pennsylvania. So you won't double pay. There'll be the Delaware franchise tax, if you do it right, is relatively modest, and you won't pay income tax in Delaware.
Okay. Maria, great question. Thank you.
Yep, thank you. The name availability, the only issue.
Wait,
got a hand up. Go ahead.
Sorry, can you repeat that? Was that corporate services, the entity you talked about that we could be able to use to establish our whatever it is in Delaware?
Mm-hmm. Yep, CSC.
CSC.
Corporation Service Company. Yep, CSC. That's what they do for a living, among other things. The name of the entity, and as others have heard me say before, I wouldn't spend gobs and gobs of time thinking about the name of the entity. I think that the name of your product or service is far more important than the name of your entity, and you can change the name of your entity later. So I wouldn't spend gobs and gobs of time thinking about that. Having said that, it is important to determine whether or not the name that you want is available in the state in which you're going to form or you're going to qualify to do business. So for example, if you pick a name, before you go very far, check, for example, you can be Delaware or Pennsylvania or whatever state, make sure it's available before you go very far. We've had people who did not do that, and then they had to go back and redo everything again.
How do you know?
Make sure it's available.
How do you check?
You go onto the website, the Delaware, each of them have a search function. So you go to the Delaware Secretary of State website, and Pennsylvania Secretary of State, look at the corporation department, and there's a search function, and you can check it there.
I would just add, it's not a legal thing, but also check for the URL,
Yep.
because it'll end up being confusing if you pick something where the URL's not available.
Yep. Yep. I actually have that further down the checklist, but yes, absolutely. Yep. The URL is important. Thank you. Yep. Cool. In the formation, if you've got a corporation, I mean, these are pretty standard pieces of paper that I have listed there, which I'm not going to go through all of them. but these will require some thought on your part. The stockholders agreement in particular, you're going to need to think through, what happens if one of the founders leaves, or what happens if you can they sell their stock? You want to restrict people from selling the stock. You want to think about who the board's going to be. And as importantly, which I probably should say here, is how much each person's going to get, right? But we'll get to that on the founder arrangements. But the point is that officers, directors, and what happens if people leave? Those are all the kinds of things that one's going to think about when you form the company. And that's the list of the documents you're going to need. A limited liability company, frankly, I mean, and by the way, if you form the entity there, you'll see the certificate of incorporation. That's what gets filed in the state in which you're going to form. Limited liability companies, frankly, they're similar. You're going to file the certificate of formation, and the operating agreement is a fancy version of the stockholders agreement and the bylaws of a corporation. It's the analog to it. So it addresses a lot of those kinds of things. I'll get to some more detail when I get to the founder arrangements. Some common things to register to do business I just talked about. You will need to file for an EIN number, a federal EIN number, as soon as you form your entity, which is pretty straightforward. But you got to file a form with the IRS and get your EIN number, and you'll need that number to open up a bank account. So that's sort of step one. In the corporate formation. So sometimes people forget about that. So you need to do that right away.
Can I apply for an EIN, but then somewhere along the way decide, oh, well, we're not going to do this business and it does not use it? Am I still obligated to do anything with the IRS?
No, the EIN won't require you to file tax returns. What's going to require you to do that will be operating. So yes, having the EIN does not require you to file tax returns. The last ones in C, their ownership records and minutes. You're going to need to keep track over time based on who owns what shares, whether it be options, ownership, etc. And so you want to keep an ongoing cap chart, which can get fairly cap being capitalization, which is a chart of who owns how many shares and who has number of options and all those good things. That's really important. And so there are companies out there that do this really well. CARTA, CARTA, is probably the preeminent one at the moment, and they have very, very good pricing for new companies because they want to get you on board early, and they will assist you in keeping track of those things. They also provide some further things down the road, such as valuations that you will need when you issue options. So it's actually a very nice thing to do, and it'll keep records later. So I recommend that startups use that kind of a business and service. Similarly, there are the minutes. I mean, it's really important to keep track and have a methodology to keep track of your of the board meetings and those kinds of things in a single place, a repository. But nobody needs the minute books that we used to have, but we need a repository of all the minutes of the board and shareholders and those kinds of things. And it's good to have that early. When you go to get financing or sell the company, people are going to ask for these things. And if you don't have it, then it's going to be sort of problematic. So it's good to just get in the habit of keeping these things early.
So David, on my minutes, do I have to document who said what and who talked all the discussion and all that?
It's interesting. So if you look at Robert's rules, it's actually very clear, which is, you should document that there was a discussion, not what the discussion was. So you should document that decisions were made and there was discussion, and that's it. No he said, she said, no direct quotes, none of that stuff. So my minutes, I refer to as moments rather than minutes, because it says we had a meeting, we discussed this, the decisions was made, and that's the end of my minutes. It's as simple as that.
So before we move on, and then also you might have some questions on this, I want to make a plug that what David is doing is giving the overview and kind of giving you the the big outline of all the things that really matter legally that for your company. But on October 26th at 5 o'clock, we have How to Form Your Startup. It's part 1. It's just the basics. And this is where he goes into much more in depth about what he's kind of giving you the highlights right now, what you need to think about. And we call it part 1 because, and I'm going to try to find the date here. I think it's the 9th. That we have a follow-up, which is called part 2, where you can sign up to participate in a workshop, and Stephanie will match you up with her law students, and you will sit down on one-on-one, and they will work with you to figure out, should you be in C Corp, should you be in an LLC, where should you incorporate, what are all those things that you need to think of. It's kind of a roadmap, but it'll be very personalized based upon your startup. You'll be under no obligation to form the company at that time. The purpose is to make you a quote unquote informed consumer. So I suggest if you can get October 26th on your calendar, and as soon as I find it, I will let you know what the date is for the follow-up on the workshop, which you have to sign up in advance so you can get paired up with the students. Go ahead then, David, I'm sorry. You can ask for questions now.
I have a question, if you don't mind. So when I read Yahoo Finance, I saw that some shareholders are listed as insider, and some are listed as institutional shareholders. I wonder what are the differences between these two, and when we accept money from maybe angel investor, would that be insider, or would that be institutional shareholders? Thank you.
Yep, good question. So for first of all, for when the distinction between insiders and non-insiders is really one that applies entirely to publicly traded companies, because you are concerned about folks buying and selling stock with inside information when it's publicly traded. The kinds of companies that we're referring to here, which are private companies, there's no public market, and so there's not really an insider trading distinction or concept as a general matter. So for what it's worth, I mean, that's really a concept that people worry about, insider trading, as I noted. Similarly, institutional investors, there is a I'll call it an informal, in my world, an informal thing, and that really relates to whether you have friends and family, angels, which are sophisticated individuals or who are investors, venture capitalists who are essentially institutional investors, or groups of investors, and then truly institutional investors, like private equity or others. That's not, again, a distinction that's particularly significant in the world of startups, with a couple of caveats. One caveat is that one of the things that we do pay a lot of attention to is to whether or not investors are accredited investors. When you go in and offer people the ability to invest in stock, you'll see, and under the securities laws, we do have to comply with the securities laws and file what's called a Form D and follow an exemption, so we don't have to register the stock. We typically try to only sell that to accredited investors, which is a defined term under the Securities Act, which includes people, for example, individuals who have a net worth of at least $1 million, or individuals who have income of $200,000, or couples of $300,000 of income, but they're accredited investors. So in the world of startups, the distinction is less those than it is accredited investors versus non-accredited investors. Cool.
Thank you so much. Appreciate it.
Yeah. Other questions? It's a great question. Well, let me maybe move sort of sideways, because we've talked about forming the entity, but we really ought to have the arrangements among the founders. So you all get together and you say, okay, well, what are the arrangements between the founders? And one of them, which isn't quite on the list here, but is how much does each one get? And in the the presentation that we're going to talk that Kit referred to, we spent some time thinking about how much each founder should get. But let me make a picture of the following. The approach that should not be the case is that you go around the room and there are and so there's the number of founders, and you take 100 and divide by the number of founders, and that's the percentage. That is not the typical way to do it, because it's based upon the amount of contributions people have made, the amount of contributions they're going to make in the future, what kind of commitment they're making, et cetera. So it's not typically just a mathematical divide by X. So it's more complicated than that. So you want to think hard about who has it. For example, there is one of the mistakes that we see lots of startups making is you have a lot of stock in people who are no longer participating or going forward. That's not terrifically healthy for the company. Investors and others want stock to be largely vested in people who have an ongoing interest and commitment to the company going forward. That's just one thing to think about as you're allocating that. Again, we'll go into the more detail about that, but just think hard about when you're thinking about this, hard about who's got how much stock. Similarly, it needs to vest over time. You'll see the reference there to restricted award agreements, and what that's saying is that the stock that the founders get or the equity they get you'll want to vest over time, so that, for example, if Kit and I are starting up a company, and then Kit decided we start the company, and then Kit decides that she'd prefer to go do something else, she doesn't walk away with 50% of the company. That we have that only portion of that is vested, and she relinquishes the rest of that stock because she only spent like a very small amount of time on the company. So the point is that the vesting arrangement, so amount of equity investing, which is in that restricted stock award agreement that's there. You'll see in the beginning there I mentioned due diligence, and when you look around at your founders, I do want you just not to walk in. I want to make sure that you've thought a little bit about, just for a moment, are there any, do they own the intellectual property they're going to contribute? Is there anybody else who has some ownership? For example, if it's a professor at one of the universities, they likely don't own the intellectual property. It's probably owned by the university, and you have to license the technology from the university. Similarly, I've run across things where the founders think they own the IP, but actually they owned when they created it, they were working for a private enterprise, and they had signed an invention assignment agreement pursuant to which that enterprise actually owned the IP. So I have one now, which they'd love to form the entity, but they're busy negotiating with their current employer to get the IP out. So question one is you have to think really hard, do they own it? And it's hidden, right? Because I mean, you may have signed an employment agreement when you went to work for a company that says the company owns the IP. So the invention assignment agreement. So we need to just pay attention a little bit to that.
So I can just chime in here too, that you have to pay attention not only just with the founders, but if you're hiring an intern or a contractor, often you do this under a contracting agreement to make sure that their employer doesn't say what they're doing when they're moonlighting, that the company, that their employer owns the IP. So.
Exactly. Yep. And similarly, the same thing goes for the item B there, both for founders and employees, which is restricted covenants. So is your co-founder or your employee subject to any restricted covenants? And by restricted covenants, what I mean are non-compete obligations or restrictions on hiring employees, et cetera. It's people don't pay much attention to these, but they are out there. And so when if you're subject to a non-compete and you're starting up another competing business, then that company can be subject to an injunction stopping you from working there, et cetera. So that's a question worth asking. So I always ask the founders, do you own the IP? Item A there, and B is, are you subject to any restricted covenants, which are non-competes or non-solicit arrangements.
David, can I go back to vesting just 1 second? I have a kind of a question. So obviously you talked about it over a period of time and 3 to 4 years or whatever, and you get a percentage of it. Is that usually tied though? Do you have a job description that goes with it, that it's not just a time, but what the other founders actually has to deliver or what they have to do?
So it's a great question. And the delivery thing, I've toyed over time with performance. There's two different kinds of vesting. One is time vesting and one is performance vesting. And so we've toyed over time with the performance-based vesting in connection with startups and founders, and it tends to be more complicated than it's worth. We tend to say with founders, as long as you're associated with it in the role of either an employee or even a director, it will vest. Sometimes you become disassociated with the company, it stops vesting. And it's as simple as that. And the founders, especially if there's more than one, you sort of take the view that if it's not working out, then you're going to leave and it's going to stop vesting. If you try to get much more complicated than that, it gets too complex, and the world changes. So I mean, we've tried to do the other, and it doesn't always work out. Now, let me also let me distinguish that from, for example, if you're a little further along and you have employees who are and you have sales and real performance milestones that you can do it on, then I do based upon performance-based vesting. So for example, if you have a salesperson, you can do it based upon the certain sales goals. If you're doing it, if you have a CEO and you want to say, okay, if you you raise a certain amount of capital or you achieve certain milestones, you can do it at certain levels. You can do that, but for startups, just when you're first out of the box, I don't suggest it. Okay.
So you probably deal with obviously what we call founder marriages, where they find each other and they form this too. What is your experience with the primary reason or the greatest reasons for what I call founder divorces? Is there a way to prevent those from happening?
So many divorces, so little time. So the I'll give you the list of the top few. The principal reason is a change of heart. It's just simply that somebody decides, I don't want to do this. I want to starting a business is hard. And it also takes a lot of commitment. It always takes longer than you think it's going to take, and there's not a whole lot of money to pay you. And so the principal reason is people just don't have the heart that they thought they had to do it. They want to go do something else. That's the principal reason. There's also people don't get along, right? But they think they're going to get along, they don't get along, and that's you try to get people to spend more time together, and part of the benefits to putting this whole crazy startup thing together is you sort of learn a little bit about working together and doing it, the process. But if you can't agree on this, and if it's really problematic and you're really loggerheads in doing this, that's not a good sign. And I've watched people do this, and you watch the way they interact, and you can almost tell if it's going to work or it's not going to work. So that's the second one. And the third one is job opportunities, which is related to the first one, but slightly different. It's not getting tired of this. You get a better offer. I mean, just get an offer to go do something else that you got to take. I mean, the world just says, go do it. Does that answer your question?
Yeah. No, that's just little preventative measures out.
Yep. I mean, it's good to talk these things out and have situations where see what you're going to do for when people leave. So that's the best thing. Let's see what else I got. People when the founders come in, they need to assign you'll see in item 6 there, an invention assignment. They got to make sure they assign the IP that was created into the company. It's important that it owns the IP, and we'll want consulting or employment agreements with the founders going forward. That's important for a couple of reasons. One is that think about the IP and what you're doing in 2 phases. One is at the formation stage. So when you buy your stock and when you come in, you need to assign your IP that's created up till then. And then that what you do during the course of your working for the company, it's important that the IP go into it then as well. So I want to make sure in the consulting and employment arrangements what folks are what they're doing for the company, what role they're going to play, their commitment, and also make sure that the intellectual property gets assigned in. Embedded that also is restricted covenants, and that's a question for you guys, which is, should the founders also sign, and employees, won't get to that in a moment, but are they going to sign the restricted covenants we just talked about, the non-competes and the non-solicits? We all know that non-competes at the moment are not looked upon very favorably. The FTC seems to be coming down on. I mean, California obviously never permitted non-competes. There's clouds out there, dark clouds on non-competes generally, but we're still putting them in. And if you have investors or otherwise, or you don't want people leaving and competing with the company, and you can invest in them, founders or employees, you think about having non-competes.
So you put that in your operating agreement or in your bylaws, or where do you put that?
Actually, that's usually in the consulting agreement. So it says while they're consulting, they're the employment agreement, they're and for a period and a tail thereafter. Sometimes you put it in the operating agreement, but I'm not a big fan of doing that.
So, but do you do that with if there are two founders? If a
Yes.
founder. Okay.
Yes. Yep.
Okay.
The only other thing I want to mention here is the immigration matters. Again, you want to check all of this under the immigration rules that Kit had indicated earlier. So what the restrictions are on employment and ownership. Just make sure that we've touched base on that. So I have just a bullet point not to forget that.
Can I just make a plug too, that in the spring semester, we held a special session on starting a business with an F1 visa, which also is greatly helpful for those of you who are planning or would like to hire or contract with students that are here on an F1 or J1 visa. So we talk about the ways to do that, or what you need, what's required. So that's where we go into more depth on that.
Before I go into employees and consultants, some of which we've already talked about, let me pause there. Questions? Hearing none. Employees and consultants, we've talked about employee agreements, consulting agreements. It's it's not, there's no law that says you have to have employee agreements or employment letters or whatever. I do recommend having them, at least letters, so that it's clear at a minimum that it's at will. So people, it's no implication that there's a long-term employment agreement. Pennsylvania, for example, is an at-will state. And you want to be clear that you can fire people when you want. It also houses, if you want, the restricted covenants that we just talked about. It's also important that you have that invention assignment that I keep talking about. That's just important. I've had maybe we're all burned by different things, right? And it's important that your arrangements with your employees and your consultants provide that what they create is signed and owned by the company. We've had transactions where people who develop software, important technology, did not sign this. They were independent contractors, and if you hire an independent contractor, consultant, and it doesn't have an invention assignment, it turns out that you don't own it, they do. You may have a license to it, but they own it, and that's not where you want to be in life. So having that clear is really important. And if you're having volunteers, which we'll talk a little more about another time, is when you can do volunteers and all that. But the point is, I want to have clear understandings with people about what the arrangements are with folks, which is why you have that as well. I have a provision there regarding employee equity arrangements, and obviously we're not going to go through all of that here, but I just do want to mention that we often reserve equity for employees, key employees. Sometimes it's you hear all sorts of numbers. General rule of thumb in the technology world is 15% of the capitalizations reserved for employees, and it can be in the form of options, restricted stock, and even profits, interest, all of which are different. There are different forms of equity, which very different tax implications to both the company and the employees. So that's an area that we'll talk more about, but it's important to think about whether you want to give equity to employees and how much. Some rules of thumb, I mentioned the 15%. I do believe that you need to give equity only to those employees and executives that you need to give it to in order to attract and retain talent. It's not candy. It's not necessarily a benefit that you should just give away because you only have 100%. If you get more than 100% of stock, then you go to jail. So that's a bad thing. But you don't want to. So I don't believe that every employee should have equity as a general matter. I think you want to reserve it to those who need it, and you need to incent people in the long term to grow the company. And there'll be a plan, there'll be equity, as I mentioned there. There's some tax implications when you give equity. The 83B election, which I won't go into here, but that's there. And you need some shareholder consent and board consent. So there's a process there to do it. I already talked about immigration matters for that, so I won't go into that. When you hire employees, there's payroll, and I seem to be today selling services. Very few people do their own payroll these days. I was just talking to somebody the other day that actually is writing checks, payroll herself, and doing all this, and with a half dozen employees. And my own view is this not, you'll screw it up, and it's not a very good use of people's time. There are lots of payroll companies out there, and so I would use one of those to do the payroll, and they will withhold the appropriate amount of taxes. They'll make sure that it gets paid properly. And so I think it's not a good, so I encourage you to use a payroll company for this. You got to think about, don't always do it, but at least think about whether we should be doing background checks on folks. Depending on the kind of business you're in, it's maybe more important than others. Some may be required to do it, right? Depending on what the kind of business you have. If you're doing something related to kids or those kinds of things, then you may think about you need to do background checks on folks. But so there may be some legal requirements. There may be some other reasons to do it. So think about whether you want to do background checks on folks. The policies and handbook, it's a very startup. You probably don't need many policies, but at some point you'll need policies and handbooks, and those are readily available as well. All right, that's it on employees and consultants, unless somebody wants to ask me a question about that.
I have a question. Can you hear me?
Yep, sure can.
So if you don't know how, I guess, profitable or operational you will be, would you still start with an employee agreement, even though you won't be able to pay those team members for a certain amount of time, or does that make sense?
Well, first of all, if you're, there's minimum wage acts out there. So there are minimum wages that you got to pay folks, unless there's certain exceptions. So if you're not paying people minimum wage or paying them cash, that's something that you need to make sure with the lawyers that you're complying with the Wage and Payment Act, the minimum wage. So start there. For example, founders, you probably don't need to, but others you do. So let's start with that piece.
Can I just chime in here that most of our startups start out with not hiring employees. In fact, we sort of discourage that in the beginning. So what they do is under a contractor's agreement, where pretty much you agree on what you're going to pay, and you do a 1099 at the end of the year, and it's up to them to pay their taxes and all that. And so usually when you're getting started, it simplifies it, gives you a chance to sort of test drive the potential employee, see if they do it, what they do it. So it avoids that payroll issue. Payroll usually comes a little bit later. But David, do you have more experience, perhaps?
I agree with that. When you do that independent contractor arrangement, you need to be very careful that they're not employees. It can be characterized as independent contractors, right? So there's a bunch of tests regarding, not taking direction and full time and just all those kinds of things. So you need to be careful that if you're going to treat them as independent contractors and not do the kinds of things you're talking about, you got to make sure you set it up as their operations as independent contractors, right?
Would that be the same if you treat them as consultants?
The consultants and independent contractors are essentially the same.
Okay, all right.
For tax purposes, they're the same. So you're going to get a 1099 rather than W-2. And as you say, they're going to be responsible for the taxes, which is all good. But this is an area which has been in heavy litigation in the last few years, where the IRS has gone off really hard on independent contractors treating independent contractors as employees of independent contractors, Uber being a prime example, but lots of others. So I'm agreeing with you as to the practice. I'm just putting a caution that if you're going to do that, let's put the right piece of paper in place and put the right package around it to make sure that treating them as independent contractor holds up.
Okay.
Did I answer your question? I found back in the original question.
Yeah.
Yeah, that was helpful. Thanks.
Okay, cool. Other questions? Right. Intellectual property matters. I just want to spend a moment on this. And it starts with non-disclosure agreements. So let me make sure that you all have non-disclosure agreements with startup, and you ought to just have a form, right? And you ought to have a form that's unilateral, which says that everybody else will keep your confidential information confidential. And a bilateral, which says that both parties will keep them confidential. So a couple sort of points on this in a practical matter. Number one is, as a general matter, I don't like to rely on a confidentiality agreement. So your true trade secrets, the real secret sauce, don't tell anybody. If there's no reason to give people source code, there's no reason to give people, as a general matter, there's no good reason to give people, the algorithms for the software. So much like our friends at at Coca-Cola, who have managed to keep that secret for all these years, we got to keep your secret and not rely on an NDA. At the end of the day, because like I say, if I'm assuming on an NDA, it means it's like I'm at the bottom of the well screaming for help, and I don't want to be there. So that's point one. Point two is that I actually, as a startup, don't always want other people's confidential information, because I don't want to have the potential risk of claiming that I used their confidential information in starting my company. So I don't always, as a startup company, I'll say this to people: I don't want your confidential information. If you want to talk about mine, we can talk about that, but I actually don't want to see yours. So just be cautious about taking other people's confidential information. Confidentiality agreements really only have two provisions that they're usually a couple pages long, but they really only have two operative things. One is that people keep the information confidential, and two is that that they won't use it for any other purpose. The only other bug I want to put in your ear about confidentiality agreements is they usually come with a term that says that the other party I'll give you my confidential information and you will keep it confidential for a period of time. People argue about 2 versus 5 years. That doesn't work. If I don't want people to have your confidential information and then be able to disclose it in 5 years or even 2 or 5 years. So there's an exception for trade secrets. If you keep it a trade secret, I want them to return it, and except they have to keep a copy. It's held confidential for as long as it's a trade secret. Really important. So that's my non-disclosure. But you should have forms available, and don't just blanket sign NDAs as if they're boilerplate, because there can be things like I have seen NDAs with invention assignments hidden at the bottom. I've seen them with the restricted covenants with non-competes in them. So don't assume because it has the caption on the top, non-disclosure agreement or NDA, that it shouldn't be looked at. So that's that. Obviously, you're going to have to, if you're working with a university or something, you're going to have to option or license the technology. That's into itself a whole nother area. I want to make a pitch for in item 3. We're talking about IP in 3 different ways. I've talked a lot in the last 54 minutes about making sure that you own the IP, that you have it assigned by the people, invention assignments. And that's been the founders, employees, contractors, making sure that you actually own the IP. The second area is to make sure that you're not infringing somebody else's IP. That's the thing where I talk about making sure that people, aren't subject to other invention assignments instead of from third parties, and maybe doing searches on the patent search and patent website to make sure that you're not infringing somebody else's patent. It is not fun to start a company and then find out that the methodology by which you're producing your product or your product is infringing somebody else's patent. Not a good time. And so doing a fairly straightforward patent search up front is helpful. And in one of the and similarly on the trademarks that you want to check and make sure that you're not infringing somebody's trademark. So we'll do a little bit of the IP one. We'll do a little bit on searching, but that's important. So I'll call that the defensive searching and IP protection. The third piece, so I've talked about ownership. I've talked to make sure you don't infringe somebody else's IP. The third one is protection for you. So you got to figure out, all right, what's that moat? What is it about mine that I can protect? And how am I going to protect my intellectual property? Now, we've talked about one methodology, which is making sure that people keep it confidential. But, are we going to file for patent protection, trademark protection, trade secrets? Are we going to use copyrights? How are we going to protect that, and what's appropriate for us? There's lots of considerations, including money constraints and other kinds of things, but there are mistakes. If you fail to file for patent and you go too forward, you do certain things and publicly disclose it, you can waive that patent protection. So I would encourage you up front to at least consider a roadmap on how you're going to protect your IP. And so you don't necessarily have to do it, but you want to make sure that you've thought about it and thought about the approach that you're going to have as a company. So that's what those items 4 through 7 are. We already talked about reserving the URL, and we talked about invention assignment matters. So that's my whole speech on IP in 4 minutes, and we'll have another section on that. Anything on that before I go on? Okay.
David, there's a question in chat that is, how does that work for biological and cellular therapies where the information is publicly available in journal articles, but isn't necessarily legally protected?
If it's available in legal journals, then it's public information. And so, you're not protecting it. You can't protect that, and presumably you can use that information to the extent it's available. So, that's good news and bad news. The good news is that you can use it and actually I had somebody do this relatively recently, where we were concerned they were infringing somebody else's IP, but it turned out it was available publicly, so that's fine. So that's okay. So it's okay to use that, but you can't protect it because it's available. So that probably would be something that would be protectable either by copyright or patent. Cool. That answer the question? Kid, if you're talking,
I'm just going to
you're on
get Reed's favorite, not disclaimer in there too. So if you're doing some sort of basic research, and of course there's always that, particularly for PhDs, there's that pressure to publish as well as to go talk to a conference. You should file a disclosure statement first with your tech transfer office, which will allow them to file a provisional patent. It's $125. It's good for a year, but that will give you the right to actually pursue a patent before you give your talk. And it is the bane of at least our tech transfer office that people go and they publish, or they go and they talk, and precludes them. I think the only place they can file a patent is maybe in the US, and there are all sorts of restrictions anyway. So go file a disclosure with your tech transfer office if you're developing university IP.
It's the disclosure is one thing, but also giving them an opportunity to file the provisional patent, because it's filing the provisional patent that protects you for the year.
Yeah, well, that's the point. Why you're filing it. Sorry.
Yeah.
The first step.
Yep. Agreed. Thank you. You know, 6 is sort of a warning that there are lots of people just dying to regulate what you're doing, and it's only getting worse. And you know, the places I'm seeing at the moment are privacy, uses of private data, privacy data. Obviously, securities, which we spend a lot of time thinking about when we raise capital from third parties. And obviously, if you're talking about FDA or other kinds of things. So one of the things that you want to do when you start is just get a sense of what regulatory scheme you are working in, and what your process is going to be to ensure that you're compliant. And the good news is that you know, if you get certain permits and approvals and those kinds of things, that becomes actually an asset because other people don't have it. And so you know, so that's a benefit. They may not have it yet, but it's important to identify early what the regulatory scheme is as it relates to you, and how you're going to comply. I mean, FDA being the sort of the perfect example. What are you going? What regulatory? What FDA require? Approvals are required. How are we going to get there? Is it phase 1, phase 2? Is it 5.0 to 510K? What is this going to be? And then figure it out. Interestingly, one of the areas that is probably the murkiest is the you know, AI, and whether AI tools require FDA approval if you're if you're predicting or otherwise dealing with healthcare. Right, so that's just one that comes to mind that one has to think hard. Does it or does it not require 510K clearance, and things like that. So that's that issue. Obviously, we need the privacy. IT protection isn't quite here, but I want to make sure that in today's world, we've really thought hard about making sure that you've done everything you can to protect your systems from people coming in and hacking it or otherwise. And that goes to protection. It also goes to there will be requirements, particularly on the privacy side or the healthcare side, that require you to have those kinds of protections. So I want to make sure you've thought about that. There are experts out there, the advisors to help with this stuff, as well as lawyers. And there's industry standards, right? So you want to make sure you comply with the industry standards. I want to touch base on contract administration. You will deal with lots of contracts. And so you'll need a form contract as relates to your customers. You'll need terms of services and privacy policy for your website. You'll need and so that's part one. That's all pretty clear. The thing that I want to make sure you've thought a little bit about is two things. One is, what's the process internally for approving signing contracts among you and your founders and employees? We've had too many where folks are just signing off on things without really thinking it through and understanding what they're signing. So is there an approval process internally for looking at these things? For example, if it's pretty important that a contract be assignable. So if you go to sell the company, you can assign it without trying to get that third party's consent, customers or vendors or whatever. And so who's making sure that those are in place? And you have a system relatively modestly priced, a checklist or something, to make sure that's in place. So that's approval for signing it in the first place. The second is a retention a administration policy or a methodology, which is a contract administration. How are we keeping track of these contracts? So you have customer contracts and things that have deadlines and obligations and reporting things. And so is there a process in place to make sure that you comply with these things? The most classic is we do a lot of leases, and so you rent space. It's got a renewal right. That renewal right's in 2 years. That date comes and goes, and so what's on your calendar to make sure that you actually comply with it? So contract administration, approval, and administration are things you want to think about as you're working through your system to do with this. Okay. Insurance I just want to make sure that we've. Let me just get 1 second. Sorry. Okay. And so you want to make sure that you have adequate insurance in place. This relates to, so you probably want an insurance broker to help you think through this. And you'll need this, particularly when you start business or you start selling, services or products. But even before then, if you have employees, you're going to want actual employees. You're going to want workers' comp insurance. You're going to want liability insurance. Usually, don't bother with director and officer insurance until you have investors. But think about that when you need that. Employment practices. So there's my point is that you want to put on your checklist to make sure you have adequate insurance, develop a relationship with an insurance broker who's dealt with startup companies, and get that in place to limit you to deal with liability. Another limitation of liability is on your contracts, but that's separate apart from that. And finally, financial. You want something in place to take care of the books and records fairly early and fairly often, well. Again, as a startup, I hate to keep saying this, but there are when you start up, there are services out there that do this pretty well. Bookminders around here does pretty well, and they're happy to deal with startup companies because they want your business later. So, you might think about hiring one of these services. Accounting firms aren't, there's difference between bookkeeping and preparing your financial statements. Bookkeeping is something that you can use both software, but you can even get services to do that. So think about that. And you want a system in place to the financial statements. You want an accounting firm to help you early on. And you sure as hell want to make sure you file your tax returns, both federal, state, income tax, and a special issue for sales and use taxes, which becomes increasingly complicated. So it's important to talk to your accountants about when you start selling, which hopefully you'll do relatively soon. What sales and use taxes do you need to withhold and charge and not charge? So put that on your list. That's my list for today.
Well, I just want to make a plug. I put some of this in chat, but we've gotten asked by a couple of our startups about payroll companies as well as bookkeepers. So we did a sort of a APB out to all of our startups and asked who they are using in both bookkeeping as well as in payroll. And so we're compiling that list, and we're also getting a few companies that they don't recommend. And once we finish that, I'll usually share anybody who reached out to me and gave me information, I'd share it with them. But we also routinely share this with Rhonda. So she can share that with her startups. And actually, Rhonda, you might have some additions or comments to that when we get further, when I share it with what we have.
Good.
That's a quick question about the check.
Maria, I can't hear you.
Checklist be shared?
Yes, I actually put it into the chat. So if you wanted to kind of scroll up back through the chat, it should be available there. But you all will be receiving an email in the next day or so with the recording as well as the checklist again. And it'll come from the Big Idea Center office. So just keep an eye out for that.
So again, just as a reminder, October 5th, our next Start Smart series is on how to protect your and other intellectual property. So all those points that David touched on will go into more depth. And then the two workshops, the two Start Smarts that are involved in company formation. The first one is November 26th, and that's part one, where they go through all those different things that David covered. And then part two is the actual workshop, and that is November 2nd. So it's 2 Thursdays right in a row. You need to sign up for that in advance so that Stephanie can assign you, match you up with law students. And for that, you'll get some information, but we just ask for a little bit of information about what your startup is to see if we can align what you're doing with some of the law students, either backgrounds or interests. So that will be our series for the fall.
Cool. Other questions? Okay.
Nice job, David.
Well, thank you.
Well
Thanks,
done.
team.
Yeah. So,
All right. Well, it's nice to see
Recommend
everybody.
hiring.
say
What's
again?
that?
One final question, just to clarify, but the first people to hire, it seems, are accountants and the lawyer, just to get that confirmed.
Lawyer than the accountants.
There you go.
Well, the lawyers in particular, because in the beginning, you don't have anything to account for because you might not have investment, you not have money. So just the same, but what you really need to do is get set up right. And as I have said before, you can recover from bad marketing advice, but you don't get good legal advice that can be fatal potentially to your company. And I will also say that not all lawyers are the same. So many people say, well, I'm going to save money. I'm going to reach out to a relative or a friend. But as I like to say, you're not going to get an orthopedic surgeon to do your brain surgery. There are people who specialize in this. And it is important to get the right type of lawyer. So Stephanie and I have actually done sessions on how to shop for a lawyer and sort of the criteria on how to find them. But make sure that this is something that they do on a regular basis.
Sounds like good advice.
Well, I wish everybody well on their startups.
Absolutely.
Hopefully this gives you sort of a foundation and it's planted the seed of everything you don't know and you need to deal with. And so in many ways, developing your product or service is the easy part. The rest, all this about having a successful company, all that stuff I say under the hood that you have to pay attention to. That's what we're here for, to give you the foundation to get you off to a good start.
Yeah, and just to reiterate, this was kind of the first one of the semester that gave the overview of all of the things you need to be, prepared to consider. And so the follow-on programs throughout the rest of the year really will dive deeper into some of these areas. Not all of it, but some of it, right? So,
yeah.
Yep.
And if you have suggestions for topics that you particularly want covered, you can reach out to Rhonda, me, or Stephanie, and we'll see what we can do.
Thank you, everybody.
Thanks, folks.
Okay,
Bye-bye.
you can stop recording, Rhonda.